Good afternoon. My name is Alex Whiting. I'm a professor here at the law school, and it's my pleasure to moderate this event, the first of two events this afternoon that are hosted by the Vera Institute for Justice and the Harvard Criminal Justice Program of Study. I have two little announcements before we get into the program. The first is that this event and the event later are both being filmed, and they will be posted on the Harvard Law School website as well as the Vera Institute website. So by remaining in the room, you hereby consent to being part of that film. It's frankly going to be the back of your head, so nothing to worry about. Secondly, we will have this event, which is, I will introduce the speakers in a moment. And as you know, since you're here, they are representatives of the Vera Institute and the District Attorney's Office in New York. This event will go to 5:15, and then at 5:30 we will have Cyrus Vance Jr., the District Attorney in Manhattan, and John Chisholm, the District Attorney in Milwaukee, both of whom are here in the room already, for an event that will start at 5:30. So I hope you will stay for that as well. It'll be terrific. So if I could just introduce the panel here, and then I am going to try to stay out of the way as much as possible and let them share their insights into this project, this amazing project on race and prosecution that they did in Manhattan. So Jim Parsons here is presently the Vice President and Research Director of the Vera Institute of Justice. He's been at Vera since 2003. Before having his present position, he was the director of the Substance Use and Mental Health Program there, and also the director of the International Program. Before going to Vera, he worked at the Center for Research on Drugs and Health Behavior and the Institute for Criminal Policy Research in London. Next to him is Whitney Tymus, who is until a few weeks ago was the director of the Prosecution and Racial Justice Program at the Vera Institute. She's now returned to Richmond, Virginia, where she is in the city attorney's office. Whitney has had maybe one of the most interesting and diverse careers that I've ever seen of a speaker here at Harvard Law School, because she's sort of worked on both sides, which is pretty unusual these days. She came to the Vera Institute in 2011 from the National District Attorneys Association, where she ran two national projects, the Gun and Gang Violence Prosecution Program and the Southwest Border Crime Initiative. Before doing that job, she had practiced law for 20 years, starting as a public defender with the Neighborhood Defender Service of Harlem. She then moved to the office of the appellate defender in New York. She then moved to Richmond, Virginia, which is your hometown, right?
Yes.
Yes. Where she was a prosecutor in Richmond for 8 years, eventually becoming the chief deputy prosecutor. And then from there went to Vera, or rather to the National District Attorneys Association. And then next to Whitney is Nitin Savoor, who is presently, his career has been at the Manhattan DA's office. He's been there for 15 years. He's presently the deputy chief of the trial division. Before that, he was most recently before that, he was the deputy bureau chief of the Cybercrime and Identity Theft Bureau. Before that, the deputy unit chief of the Identity Theft Unit, and before that, a criminal court supervisor of the Trial Bureau. So we're actually going to start with Nitin, and the question I have for you, Nitin, is can you tell us what prompted the District Attorney's Office to undertake this effort to agree to this study and to participate in it?
Sure. And if I may, first, I would just like to thank Professor Whiting and Harvard Law School for inviting us to speak on these two panels. Racial disparity in the criminal justice system is a very important subject and topic for our office, and we're very honored to be here to engage in this dialogue. In addition to my title as Deputy chief of the trial division, I would just like to add that I'm also the attorney in charge of criminal court. And for those of you who are unfamiliar with the Manhattan DA's office, we have one of the busiest criminal courts in the country. We have about 100,000 cases that come through our office every year. 80,000 of those cases are misdemeanors and violations. Another 20,000 of those cases are felonies. But that is a huge volume of cases, 100,000. We have over 500 lawyers who actually prosecute these cases. And those lawyers are broken up into 3 different divisions: the trial division, the investigative division, and the appeals division. But the lion's share of our attorneys are in the trial division. And the lion's share of the cases that come in are low-level misdemeanors and violations. So I just want to give you that little background about our office. And it's also nice to look in the audience and see Christopher Mignani sitting here in the third to last row. He's one of our former analysts who left our office 2 years ago before he started law school here at Harvard. So it's nice to see you, Chris. So before I can answer the question why the DA's office chose to undertake this study, I'm going to bring you back about 4 years before Cyrus Vance became the DA. I was not in charge of criminal court back then, but I can tell you that criminal court had a lot of problems. And the problems were related to a huge backlog in the courts. There were cases that were just churning that couldn't get resolved. Defendants could not get their trial, so we had inadequate trial capacity. We had very high dismissals because those cases that couldn't get resolved just kept getting adjourned, and eventually witnesses and victims and police officers stopped showing up. So we had high dismissals, very low trial capacity, defendants who were required to consistently appear and reappear in court. We also had excessive institutional assignments. All of our ADAs were working like 4 days a week in this court, and it was very difficult for them to work on their more serious cases. And so as a result, the shape of criminal court was not really that great. But the prevailing notion back then was that this is a damaged court. It's going to be very difficult to fix it because there are a lot of moving parts. You need the courts, you need the DA's office, you need the defense bar, you need corrections, and people were very frustrated, so very little got done. And then in 2010, Mr. Vance became our DA, and when he joined the office, he said very, crystal clear, right, these are my priorities. I have 2 main concerns. One of them is public safety, and that's keeping our streets safe and the people who live in our county safe from violent crimes. The second one is fairness. We want to make sure that the criminal courts are fair for all the people that go before the courts, whether those are our victims, our witnesses, or even our defendants who have to keep coming back. So that was his priority. And so I started working with him in 2010 on criminal court reform. And so for the last 4 years, where we've concentrated a lot of our efforts, in addition to violent crime, is in cleaning up the criminal courts, establishing really good relationships with the court system, with the defense bar, with corrections staff, to figure out ways to make the court system more efficient and more fair for everyone who's involved in it. And I have to say, we've made significant improvements in the last 4 years. We still have a way to go. But just to tell you, our first-year ADA's caseloads, if you compare the stats from 2013 year-end to 2009 before Mr. Vance came into office, those first-year assistants who predominantly handle most of our misdemeanor cases, their caseloads went down 38% because of all the initiatives, the different policies we set into place in these last 4 years, the different strategies and partnerships with the courts and implementing new parts. Their caseloads went down 38%. Our trial dismissals for speedy trial, that's when the DA's office just can't get their case together enough time, and those cases get dismissed. Those dismissals went down 66%. Our total trials increased 46%. Our bench trials went up 123%. Our dismissals on DWI cases, which we consider amongst the more serious cases in criminal court, they went down 77%, and the speedy trial dismissals in those DWI cases went down 93%. So we saw that concentrating some of our resources really had significant improvements. But like I said earlier, we still have a way to go with the work that we need to do in criminal court. But that goes back to Mr. Vance's 2 goals that we talked about earlier: public safety and fairness. The reason why we asked Vera into our office, opened our books to them, is because of that fairness. If you're looking for fairness in the criminal justice system, you really need to know, are there disparities in the system? And if there are, where are they? And how can we figure out ways to address them? So that's the #1 reason why we asked Vera, or Mr. Vance asked Vera to come in, because our goal is to operate a very fair criminal court for everyone. And it's very difficult to do that unless you know what the problems are. And it's tough to figure out those problems unless you have someone who's going to spend time to address those issues. Another thing is we thought about just exercising leadership. Our office is a very big office, right? We have a lot of attorneys. We have a huge court system. We thought if we allowed this project to go forward and made it public and allowed the results to be published so everyone could see them, this would encourage other offices throughout the country to do a similar thing, right? So that's another reason why we did it. We also realized that to do this right, you have to have a professional, independent research organization outside of our office to do it. And that's the best way that you can get the most reliable data and the most reliable analysis. Not doing it yourself. Because if you do it yourself and you make a mistake, you might not catch that. But if you give it to someone else who is well respected in the field, like Vera Institute is, that was what we decided. Now, obviously, to want to do a study like this and to be able to do a study like this requires really good data data retention and storage. And we were fortunate that our office has such a group that can mine our data and provide this information to Vera, because we provided over 220 data on 222,000 cases over a 2-year period. A lot of offices might not be able to give that information over. And now, why we were able to do that is we happen to have a group called Planning and Management. Now, 4 years ago, that was a group of few non-lawyers who would write grants and try to get money into our office to do projects. In 2010, Mr. Vance started realizing that we need to really look at data, use data to develop management strategies and to figure out how we should be prosecuting cases. So we started shifting that group into hiring young men and women who had backgrounds, degrees, master's degrees in statistics, econometrics, and these were individuals who have been working for us, and they give us monthly management reports. They memorialize all the data that come into our systems, and they make them accessible. So for example, if I have to tomorrow ask one of our analysts to let me know how many cases in 2013 did we have in Times Square where a costume character such as Elmo, Cookie Monster, Woody from Toy Story, or someone else was charged with aggressive panhandling, they would be able to write a query, go into our data systems, and come up with a list of cases in 2013. And not every office in the country has the ability to do that, but that was very helpful for us and for Vera, because we were able to provide them with that many cases, so they could do their analyses. Finally, that we also wanted to make good on an important pledge, because Mr. Vance had beforehand, before he was elected, he had promised to do this, and we wanted to do it because we think it's a good thing, and we think that other people throughout this country should also be looking at their own systems and trying to figure out where disparities occur so they can fix them. So that's basically the reasons why we engaged in this project, and we spent 2 years working with Vera, working with the researchers, Pasecki and Nancy and Jim, working with the managers, Whitney, as well as Jim as well. And Dan, I'm sorry, Whitney and Dan, and we had an excellent relationship with this team. We allowed them in, we gave them access to our paper files, we gave them the electronic information, we gave them desks in our office, computers, we work with them sometimes on a weekly basis on going over some of the questions that they had, and at the end of the day, 2 years later, a huge amount of analyses were done, and they came out with their findings, which we're about to go over in a few minutes. But it was an excellent relationship, and we had an excellent opportunity to really try to figure out what some of the problems are in our criminal justice system, and that's why we did it.
Okay, terrific. So Now let's switch over to the Vera side. Whitney, maybe you could walk us through your kind of perspective on this developing relationship and what the kind of strategy was and challenges in developing a relationship with a jurisdiction like this.
Okay, thank you, Alex. So I'll just take the group through the basic architecture of the partnership. And it's something that we've worked on over a number of years, just figuring out how to go about the process of effectively partnering with a jurisdiction and making the work productive and useful. And actually, the work started in 2005. I just wanted to acknowledge the presence of the Honorable John Chisholm, who's here from Milwaukee, Wisconsin, who is one of our very, very first partners. So we've been developing a partnership model through the years, and I'll be plugging in what happened in Manhattan to illustrate how this has been refined through the years. So let me just take a step back. And for those of you who aren't familiar generally with what we've been doing at Vera, in 2005, Vera started a program called the Prosecution and Racial Justice Program. And the objective of the program was to partner with prosecutors' offices to help them understand in the aggregate what impacts their decisions we're having. And so not to look at individual cases and say, hey, in the case of John Doe here, this happened. In the case of Jane Doe, this is what happened. But to look very broadly and help our partners see clearly at every stage at which prosecutors exercise discretion what the aggregate outcomes were and if they were racially fair or if there was cause for concern. So that's what we've been about. The project is Prosecution Racial Justice Program. It's a mouthful, so let's just call it PRJ, all right? So that's what we embarked on. And we found through the years that it really mattered a lot who our partner was. So I'm going to talk to you a bit about how we identify partners, how we made decisions about whom we should be partnering with. Also to talk about, I'll be talking a bit about the process of building relationships with our partners, with project startup and sort of some of the logistical factors that we considered, issues regarding understanding the jurisdictions that we're working in. Jim's going to talk about the analyses themselves and what the findings were, so I'm going to skip over that part and then talk a bit about the deliverables of the project, the reports that we have developed through the years, and specifically in Manhattan, how we went about doing that. So let's just start with identifying a partner. What makes a partner a great partner? So Manhattan was an ideal partner for us for many reasons. You know, as Nitin says, Manhattan has a very robust data management system, and so since we're doing scientific research, that was essential. But even more important than that is the commitment to the goals of the work. And so Mr. Vance, even prior to taking office, stated that he was going to be focused on fairness, as Nitin has said, and it was clear to us that this is a partner that shared our goals. And so that's the number one piece of this work, is because, you know, if you don't share goals, you can have the best data in the world, but at the end of the day, the partnership will completely unravel. So we started out with a strong partner that shared the goals of really getting to the truth, and a partner that was able to do that because it had the capacity that was necessary for the work to be seen through. Also, this one point, you know, many offices in the United States are not as large as Manhattan. Most prosecutors' offices are nothing like the size of Manhattan, but Manhattan afforded us a very unique opportunity. As Nitin said, there are 222,000 cases, a little bit more than that in our data set. So that allowed us to really have a very robust data set that we could learn from, and not to have to go way back in time to have enough cases so that the findings would be meaningful. Does that make sense to everybody? Okay. So that's, those are some important factors in identifying and deciding, okay, who are we going to partner with? So this is really wonderful opportunity for Vera to work with Danny. Regarding relationship building, I don't think I can say enough about that. There has to be an enormous level of trust to complete this work, because we're going in, somebody referred to Vera as termites once. I mean, really, we're crawling all over everything. We're getting into the weeds, you know, getting into a ton of files. Danny didn't refer to us as termites, it was someone else. But really, I mean, it's a very intense process, and there has to be an enormous amount of mutual trust in order for the work to get done. So that's the key. That's a very essential piece of building relationships. Also, it's important. It was important for us to have somebody in that office that we could call on day or night. And Nitin, you've gotten calls from me, I think, at late hours and on the weekends. And you know, it was just. And I know that the research team called on Nitin in that way. We could always reach out to Nitin, no matter what time, and get a very quick response and a genuine concern that the questions that we had be answered quickly. So having that person that we could talk to was key. And Nitin introduced us to the line prosecutors in the office, to bureau chiefs, and to essential personnel that we had to get to know. There was a working group of analysts that the researchers engaged just daily. So that was those were all the important aspects of relationship building that I just wanted to highlight for you. So these were some preliminary pieces of the work. Get a great partner, start building relationships. So from there, we were in a position in Manhattan to get off to a quick and a productive start. And so let me just move into startup and logistics a bit. So when we began the work, we had a ton of meetings. We met with all of the analysts to understand their data sources, to learn how the systems stored information in the office. We embarked on the work with an MOU. This was the first time that we partnered with an office and had a memorandum of understanding that really spelled out goals, roles, tasks, guidelines, everything that was going into the work. Confidentiality, all sorts of things like that were memorialized in the MOU, and that was an essential component of doing the work in Manhattan. And that was the first time that we had actually had an MOU. So those are some things that went into startup and logistics. Another important aspect of partnering with Manhattan was understanding Manhattan itself. And that's the case with every jurisdiction. It's key to understand the laws in the jurisdiction, to understand the culture in the jurisdiction, you know, to understand personalities, relationships. And so we had a lot of tours. We met with just a wide variety of people. Nitin set up, you know, just a great orientation for our team. And so that allowed us to have the understanding that we needed to make sense of the findings that would come later. We also had qualitative interviews with a range of prosecutors in the office, and that was very fruitful for us as well in terms of understanding the office and its jurisdiction, and the jurisdiction. I just want to take a minute, and I also wanted to acknowledge another esteemed, well, we just have so many honored guests in the room, but Carter Stewart is here, a United States attorney from Ohio, and we're just very honored to have you with us here today. Thank you. So let me just move on. So identifying a partner, building relationships, startup and logistics, understanding the office and the jurisdiction, those were key things, and that moved us into the process of collecting data. So that's when our researchers came in and started really crunching the numbers. And all of the things that led up to that were essential to making sense of the data. So based on conversations with Danny, Vera determined what data sources we would use and what discretionary points we would look at, and those decisions were made based on all of the background work that came before. So let me just skip over the analysis itself. Jim's going to get into that. The work culminated in a major deliverable. I didn't mention, I don't think, that this work was funded largely by the National Institute of Justice. And one of the deliverables required by that grant was a very lengthy technical report. It was over 200 pages long, and its drafting and refinement was very intense, right? And there were some other written deliverables. There was a shorter policy brief. There was also a brief that outlined the partnership, and I would just ask you all, if you're interested in any of these things, they're up on Vera's website. You can hit the website and have access to all of these reports. So the report development process, again, it was very intense. It involved a lot of meetings with high-level people. Mr. Vance met with us about the reports. We met often with Nitin and with Karen Friedman-Agnifilo, who is the head of the trial division in the office. And so it was essential to developing the reports that we had the full support and buy-in of the highest levels of leadership in the office. And so we were able to achieve that, and that process went very well, even though I'll say, you know, developing reports like that, it's tense and intense. And so that's to be expected, I think, with any partnership. But you know, that's what we were able to do. So in conclusion, really, I just want to wrap up by saying that mutual desire and commitment is the key thing to this type of work. A desire on the part of our partners, not just to support the work at its early stages, but really to see it through, and then after the findings are released, to do something about them. And so that's what we were able to experience with our work in Danny, and I'm going to let Jim talk to you guys about the analysis itself and the findings. Thanks.
Okay, thank you, Whitney. So Jim, the stage is set. There you have collaboration, enthusiasm on both sides. What did you do?
Thank you, Alex. And I'd also like to thank Harvard Law School for having us here today, and to recognize D.A. Vance's courage and innovative spirit in terms of working with Vera on this project. I'd also like to mention that this is work that was conducted by my colleagues at Vera, Basiki, who and Nancy Andalora, who Nitin and Whitney referred to. So I'm here on their behalf. I'd like to give you a quick overview of this project, what we did and what we found. This is in terms of methodologically, is a detailed study. I'm going to err on the side of not going into so many of the methodological details, although I can certainly provide more information if that would be helpful. But I'll give enough so you can understand the contours of what we did, and then dig into some of the findings and the results of the work. It's important also, Whitney mentioned this, but this project was funded by the Department of Justice, and that means that they have a criteria for reviewing proposals and also for reviewing products before they're released. So this is work that was conducted by Vera, but there are a cast of other experts and academics who stand with us, and who we used as a sounding board and as a way of checking and validating our results. The aim of the work, as was already been mentioned, is to understand how cases flow through the Manhattan courts. And we focused on key discretion points during that flow from a case being forwarded by the police department through to the disposition or the outcome of the case. And so in terms of racial disparity, there are key points in a case where it's important to measure how the outcomes differ depending on the race and ethnicity of the defendant. And so we chose some of those to provide a framework for the analysis. So first we looked at case acceptance rates. So whether a case following arrest was accepted by the Manhattan DA's office. Then we looked at pretrial detention, so whether the defendant was held in custody, which of course is not solely under the control of the DA, but is something that we thought was important to look at because it has such a bearing on case outcomes. We looked at cases being dismissed after they'd initially been accepted, and then we looked at plea offers, and we looked at sentence outcomes. So in doing this, we were able to unravel, if you like, to look at what happens to a case along as it progresses through the court system. So to give you a sense of the cases we looked at, Nitin has already mentioned we looked at cases from 2010 and 2011. That's just over 220,000 cases. A very large sample, which allowed us to do a rigorous analysis. Of those cases, just almost three-quarters, 74% were misdemeanors. We also included violations and felonies, which were each about 12% of the cases we looked at. And we took a smaller sample. So we used all administrative records from the DA's office, but then we did some case file reviews, which basically meant that for a smaller number of cases, we actually went to the paper records maintained by the DA to record information that wasn't available in the administrative record. And so we did that for about 1,200 misdemeanor marijuana cases and about 1,200 felony non-marijuana drug cases. And we also interviewed a number of people from the District Attorney's Office to understand how we should interpret the information. I think Whitney mentioned this, but the quantitative data, the administrative data is extremely important, but often there's a story that underlies that which needs to be understood if you are able to interpret it and conduct the analysis. So we thought that was important. I'll talk about the analysis we conducted, which is looking at race and racial disparity at those key points, but also controls for other factors. By this, what I mean is, if you were just to look at the conviction rate, for example, by race, you might notice that there was a difference just in that simple bivariate analysis, just looking at percentage of whites and percentage of blacks or Latinos that were convicted. You might notice a difference. However, we investigated those relationships in more detail because we wanted to know the extent to which that difference was explained by other factors. So was it the case that someone from a particular racial or ethnic group had more prior convictions? Was it they were facing different charges? Was it that they were facing more charges related to that particular arrest? Which obviously all can affect the outcome of a case. So in order to provide a useful assessment of the impact of race and ethnicity, we wanted to say, if we use statistical techniques to control for those, so if we're comparing like with like, apples with apples, what can we learn about the impact of race and ethnicity? And we looked at 4 different groups in terms of looking at race and ethnicity. We looked at whites, blacks, Latinos, and Latinos includes people who reported their ethnicity as being white Latino and black Latino. In our analysis, we included those people as Latinos and also Asian. And these were codes that were coded by the New York City Police Department, so that's where we got the race and ethnicity data from. Of the people who are in those just over 220,000 cases, about 83% were male and the average age was 34 years. So I'll go over some of the findings, and we looked at both the overall findings, so for all cases, and also we, in some cases, looked at individual types of offence. So we looked at, for example, property misdemeanors, drug misdemeanors, drug felonies, property felonies, etc. Because what we found is that sometimes decision-making is different based on the type of charge. And again, in terms of feeding back information which is useful to Danny, to the DA's office, I think that kind of fine-grained analysis is really helpful. So first, I mentioned case acceptance. What we found was the overwhelming majority of cases were accepted following arrest by the DA's office. Almost 96% of cases, when they were arrested and forwarded, were accepted at that initial first acceptance point. And what we found is that there was not any difference based on race and ethnicity on those acceptance rates. So the vast majority, regardless of the race and ethnicity of the defendants, those cases were accepted. The next point I mentioned that we looked at was pretrial detention. So whether somebody was released by the courts, either released on their own recognizance, or whether they posted bail versus being detained. And at this point, we found that when you control for other factors, there was some difference based on the race and ethnicity of the defendant. We found that that blacks, African Americans, were 10% more likely to be detained. Latinos were 3% more likely, and Asians were 21% less likely to be detained when compared to their white counterparts. So defendants who are controlling for other differences in the defendant characteristics in the charge for similar white defendants. So that's one point where we found there was a difference. When we looked at the dismissal rates, so this is dismissal at any point following the initial acceptance. So as I mentioned, just, the vast majority of cases were accepted. There are several points between that acceptance and the case being disposed where a case may be dismissed, ACD'd, or for other reasons. Nitin mentioned there could be speedy trial provisions that mean a case is dismissed. There could be a lack of evidence or other reasons that a case is not pursued. What we found is that about 23% of cases were dismissed following the initial acceptance. And again, there was a difference in dismissal rates by race and ethnicity. We found that there was 9% greater likelihood that cases involving defendants who are black or Latino would be dismissed following the initial acceptance, and that cases involving Asian defendants were 2% more likely to be dismissed following that initial acceptance, which is an interesting finding that we can dig into in a little bit more detail. So then the next area we looked at were plea offers. We found that we looked at two different aspects of plea offers. Those, an offer which was made to a defendant based on the charge that they were being asked to offered to plea to, and then also the sentence that was part of the plea offer. And for the sentence, we were particularly interested in whether that plea offer included incarceration. So whether the offer was, if you plea to this charge, you will be, you will receive a sentence which involved either jail or prison. That was the point that we thought was interesting, important to look at. Again, we broke this down. What we found was that for misdemeanor cases, the plea offer was more likely to include incarceration if the defendant was black, 13% more likely. If the defendant was Latino, 5% more likely. If the defendant was Asian, 25% less likely. So again, and this is all being compared to white defendants. So again, at this point about the offer that's being made to a defendant when their case is in the court system, there was a difference by race. That's for all misdemeanors, and we found there was a greater difference for misdemeanor drug offenses. So a black defendant arrested on a misdemeanor drug charge was 27% more likely to have a plea offer which included incarceration than a white defendant, and Latino is about 18% more likely. So as you can see, we use this analysis to track a case right through to the sentencing, and again, we are interested in custodial sentences. In terms of sentencing, blacks were 5% more likely than whites to receive a custodial sentence, and Asians were 19% less likely. And again, that differed by the type of charge. So misdemeanor person offences, blacks were 15% more likely to receive a prison or jail sentence. Misdemeanor drug, also the same disparity, blacks being 15% more likely than whites to receive a custodial sentence. Just in conclusion, we found that there were different things happening as a case proceeded through the court system. We found initially there was no difference in the acceptance rates based on race and ethnicity. We found pretrial detention, that blacks and Latinos were more likely to be detained, Asians less likely to be detained than whites. And pretrial detention is, as we know from other research, is an important decision point. Somebody who's detained pretrial is more likely to receive a custodial sentence than somebody who is released pretrial. So that's an important point to look at. And then cases being dismissed, we found that blacks, Latinos, and Asians were more likely to have their case dismissed. And then when it came to pleas and sentences, the disparity was in the other direction. And through to sentences, blacks and Latinos being more likely to receive a custodial sentence. And so we provided, as Whitney and Nitin mentioned, we produced this into both a very detailed report to the Department of Justice, our federal funders, which is always a requirement of these grants, and also some academic papers that Basiki and Nancy worked on, and then also some policy briefs to make these findings accessible to people around the country who might be considering a similar analysis as a way of understanding what's happening within their own offices and shining, a light on where attention is needed in terms of decision making. So that's a very quick tour of what we did as part of the research.
Before I turn it back to Nitin to talk about where the office has gone since learning of these findings, can you say a little bit more about the dismissal rate, about what you drew from that? I mean,
sure.
Initially, that might look counterintuitive or surprising or different, but maybe there are other explanations which make it make sense in the context of the other findings.
Sure. So the dismissal rate, I think, has to be viewed in tandem with the acceptance rate. Mm-hmm. I think the fact that many charges, that the vast majority of cases are initially accepted, and then a fairly significant number are dismissed, often fairly soon after that initial acceptance, is something which has to be looked at together. So there's no disparity in the cases that are accepted, but then the fact that more cases, the cases involving blacks and Latinos are more likely to be dismissed, could say a few things. One is that if the reason that case is being dismissed is because of evidentiary reasons or to do with the arrest, there's maybe a question about the initial acceptance rates, whether some of those cases should be accepted in the first place. We don't have, that's, to be honest, is conjecture. That's one interpretation. That is something that would frankly require more information that looks at the evidence that's available in different types of case. So that's just, you know, it does seem somewhat counterintuitive if you look at the later steps that happen in a case. That's one way of interpreting it. But this is one area where the partnership that we've built with the Manhattan DA's office, building on this analysis and really kind of course, with research, often raises almost as many questions as it answers. When you start to look at the data, you often identify areas where there's a need perhaps for a little bit more analysis, and this is probably one of those areas.
Okay, but I take it that the statistics you found were nonetheless, even though they raise lots of questions that need further study, that they are statistically significant and meaningful.
Everything that, I mean, this is the statistics that I quickly went over just now are a selection of what you found, but I didn't mention anything unless it was statistically significant. So unless it met that kind of benchmark for being something which is a real difference rather than just being explained by chance, by random fluctuations in the data. So yeah, everything else, yeah, it's all significant.
Alex, yeah, thank you. I just wanted to add that Jim's reference to case acceptance rates being, I think you said the vast majority of cases were accepted. For the audience's benefit, we're talking 96% of misdemeanors, right? And 94% of felonies. So, okay. So those are the numbers.
Okay. Okay, so Nitin, now this comes back to you.
Sure.
And your office.
Sure.
When you learned of these numbers, were you surprised?
Well, let me first say, first and foremost, we were very grateful to Vera for providing us with this study. Right? And as you heard Jim say, in some of these discretion points, there was no disparity. In some, the disparity actually went the opposite way than what we expected. In other areas, there was disparity, like 10% in some areas and even higher. Our position is that we're very troubled by these numbers because there should not be any disparity in the criminal justice system. And the perfect system is a system where there's no racial disparity. So that's what we're striving to actually accomplish here. I think everyone should be, right? As far as what we've done with this, there are a few things that we have already started doing. Remember, this data is from 2010 to 2011. So let me first talk about some of the things that Mr. Vance put into play when he came into office that could affect future studies if we were to rerun the same study using more current data. So one thing he did was, as soon as he came into office, he started a conviction integrity unit. And the sole purpose of this unit is to really address claims of actual innocence and to make sure that there are no wrongful convictions. And so this unit, so far, they've reviewed more than 160 cases, and they've reinvestigated at least 13 of those cases. And our office has consented to vacate convictions in 4 of those cases so far. So we think that's a very important thing, to make sure that when someone is prosecuted by our office and other offices, that they are properly prosecuted and it's not a wrongful conviction, right? They weren't unjustly prosecuted. And some of those cases that we did reinvestigate were murders and very violent crimes such as rapes, burglaries, and robberies. So that's something we've done already. We've instituted in our office as a practice going forward. Another thing that Mr. Vance has done is he's developed several specialized courts throughout criminal court and Supreme Court. And this is all in 2011 to forward, after this data came in. And some of those courts include a quality of life court in criminal court that deals with low-level misdemeanors and violations. Another court is the mental health court in Supreme Court that deals with violent crimes and felonies involving those that have mental illness or behavioral health issues. There's a human trafficking intervention court that deals with prostitution offenses in criminal court. And there's also an adolescent diversion youth part that deals with misdemeanors and violations for those who are between the ages of 16 and 17. And by starting these specialized parts, in partnerships with the courts and the defense bar and social service agencies, and putting all these cases before one judge that has specialized training, what we're trying to accomplish here is to make sure that the outcomes are consistent and fair by having them placed in one place. And so that's another thing that we have done since this data has come out. But since the report has come out, we are also in the process of and have been doing other things that I'd like to talk about. One of which is we have appointed a chief diversity officer and diversity committee for our office, and they're tasked with strengthening and the diversity of our workforce, and also developing and training and mentoring in this area. So we think that's a really good thing. We're also committed to making implicit bias training mandatory for all of the attorneys in our office, and we're looking to do that shortly. We have, or Mr. Vance has publicly called for decriminalizing small amounts of marijuana that people hold open to public view. He's done that in the past. The legislature did not enact that statute, but for those of you who are not familiar with New York criminal law, it's a B misdemeanor to possess a small amount of marijuana in a public place and that's open to public view. However, that same small amount of marijuana, if instead of possessing it open to public place, open to public view, if you instead have that in your pocket or inside your jacket or somewhere where it's not open to public view, that's a violation and not a crime. So there is in the law taking the same amount of weed and on one hand charging it as a violation and on the other hand charging it as a B misdemeanor, which could have consequences. So Mr. Vance has publicly called for making those the same crime, which should be a violation. Now that did not pass with the legislature. So what we are now doing is we're supporting the mayor's initiative, which went into effect yesterday, where the NYPD now, if they see a person who possesses marijuana open to public view, they're going to charge them with a violation, not arrest them, and give them what amounts to a summons, a ticket to appear in a summons court, not a criminal court. So as a result, those arrests for those types of low-level marijuana offenses will drastically be reduced. We approximate about 4,000 people will no longer go through the criminal justice system and instead will be issued these tickets to show up in the summons part.
And just quickly, just to jump in there on the marijuana piece, that was one of the offences where, as I mentioned earlier, that we saw particular disparity in. We know, I think, that there's disparity in arrest for marijuana possession, but also we saw disparity in terms of the plea offers and those things. So that's an area which, you know, thinking about those cases, I think, is a particularly welcome approach. Yeah.
In addition, our office last year prosecuted about 12,000 violation cases. Now in New York, you have felonies where you can go to jail for a year or more. You have misdemeanors where you can go to jail for up to 1 year, and you have violations, which are not crimes, but you can go to jail for up to 15 days. The majority of those people came to our office charged with violations because they had a warrant, they didn't have ID, so they were forced to be put through the criminal justice system, arrested, as opposed to being issued a ticket to show up in the summons part. Mr. Vance has been working with the NYPD, and what our next steps are to take about 12,000 of those cases that we prosecuted last year and no longer prosecute them, and have NYPD bring those same defendants, in lieu of arresting them, issue them a summons to appear in the local summons part. So that will include marijuana offenses, but a whole host of other non-criminal offenses as well. So they'll be taking a large chunk of the low-level cases that we prosecute in Manhattan Criminal Court and transferring them out, which I think is a very good thing. In addition, we are in the process of doing a pre-arraignment diversion program. And let me explain to you, most of the, in our office, when a defendant is charged with a misdemeanor, several misdemeanors, they are entitled, or they're eligible, based on our first arrest plea guidelines, to receive what is known as an adjournment in contemplation of dismissal. It's called an ACD. And what that basically means is that if you consent to this, you don't need to plead guilty, but if you consent to this, your case will be dismissed and sealed within 6 months. Now, sometimes there's a requirement to get this ACD. In the shoplifting case, we might ask the defendant to do a 1-day stop-lift program. If it's a drug case, we might require the defendant to do a 1-day treatment readiness program for drugs. But the whole gist of it is that it's your first or second arrest. You don't have an extensive criminal record. Our office does not want to give you a criminal record, so you can consent to this ACD, do your 1 day of social service or community service or program, and the case will be dismissed and sealed in 6 months. So that's what happens on a majority of the cases that go through criminal court, because they usually involve people who don't have criminal records. So what we're looking to do is working with the police department in lieu of bringing them into criminal court at all. We are working with the PD to instead give them an arraignment date 9 weeks in the future. So instead of arresting them, bringing them straight to arraignments within 24 hours, we are telling the police department, issue them a desk appearance ticket. Have them come to court 9 weeks later, but we'll give them the option in that 9-week period to undergo and do this 1-day program, whether it's the drug treatment program or a shoplifting program or whatever the program is. If they complete that before their court date, we will not require them to go to court. We'll decline to prosecute that case because they successfully completed a diversion program. So in essence, a person who was arrested, was told to show up in court 9 weeks from now, will no longer have to appear in court. The case will be just dismissed and sealed. It'll be declined to be prosecuted, which is basically a sealed arrest, right? So that's what we're looking to do. We're piloting that with 16 and 17-year-olds in the next month and a half. And we started with just one precinct, but we're looking to do that throughout Manhattan for all 16 and 17-year-olds. And that's going to amount to about 1,300 cases right there. And then once we work out all the kinks in that plan, we intend to do that for adults as well. So the whole purpose is to avoid people coming in through our court system. Give them an opportunity to get their case DP'd, right?
Okay. So let me flip it back to Vera and ask you, what are other things that you would like to see the District Attorney's Office do to address these findings?
Well, I applaud the implicit bias training and the things that that Nitin is talking about, and just in a very broad sense, whenever offices are thinking institutionally about change to address racial disparity, that's a really good, that's a very good thing. I mean, there's a difference between looking at the problem as one to be solved just on an individual level, and looking at it as something to be addressed at an institutional level. And the things that Nitin is talking about, the things that he's addressed, are institutional changes. They're things that John Chisholm, for example, in Milwaukee, they instituted diversion programs and deferrals and institutional changes. So those are the types of things that that are very necessary in addressing this work. So I'm delighted to hear about this and hope that institutionally that there will be an institutional focus around these issues. So and I turn the question to the group as well. I'm looking at my friend Dave Laban here from the Association of Prosecuting Attorneys. Prosecutors are starting to address issues in a different way, and your organization is providing a platform and a forum for people to be discussing forward-thinking change. And so, I'd ask, do you have anything to add in terms of what's happening out in the field right now? I know that a couple of years ago in New York, for the very first time that I ever was aware of, there was a convening that brought together prosecutors and defense attorneys and just a huge variety of people in the criminal justice community to talk about, to speak institutionally about reform around racial justice. And so these are conversations that are really just beginning to be had for prosecutors, I think. And is there anything that folks in the audience would like to add?
I think you touched on it. I mean, that's the difference is the leadership. And John Chisholm is my board chair, Cy Vance is on my board.
If you don't mind, 'cause I'm not sure everybody caught who you are. So if you could just introduce yourself and where you're from.
Good evening. My name is Dave Laban. I'm the president and CEO of the Association of Prosecuting Attorneys. I'm here, just came up from D.C. And,
thank you.
Also, I see Leroy Frazier here from now the Brooklyn office, but previously the Manhattan office. I think what he's trying to say is prosecutors are getting much more proactive. What can we do? In the past, it was the police and the community policing looked and said, how can you change your community? It's now doing the prosecutors. Are we making a difference? Is the action that we're taking going to make that sort of a change? And then the convening that Whitney talked about, and that was the sea change for our organization, is to say, instead of fighting over, are there disparities? Let's not even have that discussion. Let's look and say, there are disparities. What are those disparities? And within our world, within our court system, when we touch that case, can we make it better? Are there things that we can do that can get rid of some of those disparities, or at the very least, not make it any worse? And it was an excellent convening, but it requires that leadership, and it requires it from above to say, we want to do things differently, and then most particularly as it relates to Vera and this work is, give us the research. This kind of work, all this data, and the real cases, is what causes people to change. Is that they can look at it. It's very hard within Danny's office, and I have told your different assistants, but those that touch this project, how can they walk away from this and say, oh, there's nothing we can do, there's no reason to change, there's no reason to have any alternatives, whereas even as we were chatting here, I think that you are looking at how can we do alternatives and divert, and how can we keep cases out of the system, and I think that's the other sea change for prosecutors. In the past, we weren't necessarily thinking how we keep them out, we were thinking of the cases we've got, what's our best and highest use of the resources. So thanks.
Professor, can I add one thing?
And then Jim wants to jump in.
Sure. So Jim had mentioned that there was some disparity in pretrial detention for misdemeanors, and there is a program that we are funding. Our office is going to fund citywide. That's supposed to happen in the next few months, and it's a misdemeanor supervised release program, which is something that we don't have in criminal court. So in a normal case of a misdemeanor that's brought in front of an arraignment judge, the judge has a few options. One is to set bail, or the second option is to release that defendant under their own recognizance. Now, what happens if you have a defendant that has a few bench warrants in their criminal record, and the judge feels that this defendant might not return to court? Usually bail is set on those cases. So here is a third option other than just ROR, release on their own recognizance, or setting bail, where a third party will come in and they will take responsibility. They'll approach the court and they'll say, Your Honor, if you release them to our custody, we'll ensure that they come back to court. We'll be meeting with them regularly between the court adjournments. We'll give updates to the DA, to the defense attorney, to the court. And if this person fails to comply, we'll let all the parties know so you can order a bench warrant. But we'll do this with the hopes that you will not set bail. And I think this program, which is something that we are very much involved in, I think this is going to have a significant impact on disparity in pretrial detention.
Jim?
So just quickly, so the findings that I described, as I mentioned, control for a range of other factors. So if you just look, as I mentioned, the disparity between outcomes if you're white versus if you're black, and you don't take account of things like how many prior arrests, charge, defense counsel type, there are much bigger disparities. And that raises an interesting question, because I think it raises the question about why is it that defendants of color have more prior arrests, more prior convictions, less access to private counsel. And so I think that also triggers a number of further conversations about how we address those kind of factors and how perhaps those things which are implicit, those things which are the product of the way that our criminal justice system has operated, that means that people accrue more prior arrests and convictions. Perhaps we need to think about the extent to which that's influencing decision making for people who are at that point now, and you know, how we counteract that accretion of policing policies, for example, which tend to lead to higher rates of arrest of people of color, how we perhaps start to readdress that when it comes to the court system, because those things are obviously leading to differential outcomes.
No.
Okay, I just, the policy brief that that we referred to earlier does have some commentary in it about some things that Vera thought were important to look at, one of which was office's reliance on defendants' prior arrests rather than convictions, as Jim was touching on, and that's an incredibly important point, okay, particularly for jurisdictions that are in very racially charged. I'm just looking at David Harris here, who's a leading scholar on policing. Okay, so you have a jurisdiction like New York City that everyone's heard about, you know, all of the work around stop and frisk. And David, do you want to say something about prior arrest and how, well, let me just stop. I just saw you raising your hand, so.
You can make a comment and you can also ask a question.
Yeah. Sure, I'll do that. David Harris from the University of Pittsburgh. I'm glad to say I've been on the advisory board for the PRJ project since its very first day. It's a wonderful thing. It's been great. My comment in response to Whitney would be, you have to look at the system as one long journey. And the getting arrested part is what feeds you into the getting your case accepted part. All these things are related. And so it calls for this kind of work informing the prosecution to also spread out to be part of what the police learn, and vice versa. Yeah. I guess the question I have is for Nick. I think what you've done by way of reaction are all good steps. And I'm wondering what you're planning in a year or 2 years to follow up to see if your steps have brought the disparities down to where you would want them.
And that's why we have such an excellent planning and management team. And again, they are specialized in multivariate regression analysis, things that most of the lawyers in our office know nothing about, but they specialize in. So what they're going to do is they're running these, they have the data set, so they have a comparison. So they're going to run a similar data set, a 2-year set, to compare how we're doing. That's our next steps.
Okay, I want to open it up. Please.
Yeah, I had just a couple of specific questions about the study. You talked about detention disparities. Did you look at disparities in bail requests by race? So that obviously it's not totally the control of the prosecutor, but what they were requesting. Because often what the prosecutors request, you know, ROR or can certainly influence the judge. That's one question.
We did look at the different types of release, so whether someone posted bail or whether there was an ROR. In terms of amounts, I would probably refer you to the technical report. I don't think we had data available on bail amounts.
Yeah, I believe the report focuses on ultimately what the judge did, not what the prosecutor requested. So in a situation where the prosecutor might have consented to a defendant's release, but the judge said, no, 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 I'm going to set $500 bail, that's the data that Vera got, was that $500 bail was set.
So not whether there were disparities in the bail requests. Okay. And then I was just wondering, if you wanted to, I understand this is an institutional issue, but if you wanted to control for or look at, let's say, blacks were this much more likely to be imprisoned in front of this judge, or in front of this judge with that DA, not to see if there are bad actors in the system. Could you do that? And along those lines, are you talking to the judges in New York about this report, about implicit bias training? Because clearly they're participants.
Yeah, that's an excellent point. I mean, so for some of the more kind of deeper dive case file analysis we looked at the prosecuting attorney, we looked at the caseload of those prosecutors. In the summary that I prepared today, and again, I'm presenting on behalf of my colleagues here, I don't think that those were predictive in terms of outcome by race. I again would advise you to check the report, and I can certainly do that after this presentation. But we did have limited ability to look at that. That wasn't something that was available across all cases, but we did take a deeper dive and look at that in some cases. And as I say, that wasn't something that was predictive. Also, there's some other things we didn't have. So we didn't have information on kind of victim characteristics, for example. Some other things which we know are likely to be important in terms of outcome. And also, I should have mentioned this when I was going through the results, that there are many things that are more predictive than race and ethnicity in terms of outcomes. As I mentioned, counsel type is very important. The charge, criminal history, those kind of things are also very important. I think it's important to put race against that backdrop of other things which influence case outcomes. In terms of talking to the judiciary in New York, we haven't organize a briefing that specifically targets the judiciary. I think that's an excellent idea, and we want to communicate this as broadly as possible, both about what it says about New York, but also some of the methods that could be useful elsewhere. So yeah.
We have spoken to some other judges, though. We did address the Third Circuit Judicial Conference this year, and that would be great, though, to do it in the second.
Sonia.
So I'm interested in the interplay of how earlier stage decisions in the process affect the ultimate disparities in outcomes that you see. And so I'm curious, I think you guys maybe don't have like charge magnitude data, that is how severe amongst felonies, for instance, cases are. But you do have this, as you mentioned, you have the bail decision, and as you mentioned, bail can be a predictor of whether somebody gets a long sentence. So I'm wondering what your data can say about how much racial disparity in ultimate outcomes, like whether they go to jail for how long, is predicted by the initial bail decisions. So the idea here is that the initial bail decision can affect the terms of plea bargaining and influence the judge.
So in terms of the progress, in terms of the extent to which a prior decision affects a later one or a later outcome, in terms of the way a case passes through the system, and just to give a bit more explanation. So the idea, right, that if more cases are dismissed for a particular group, you might expect the cases that remain to have more punitive outcomes because perhaps some of the less serious cases have already been dismissed. So, I mean, the point is that you need to take account of what goes on before, and about pretrial detention, the fact that, as I mentioned, and you repeated, that it's a strong predictor of receiving a custodial sentence if you're in pretrial detention. We controlled for two things. So the analysis controls if someone was held in pretrial detention. We control for that in the later analysis of outcomes. We don't use that as a way of saying to what extent is disparity explained by that pretrial detention, but there is, we do include that in the analysis, and also we control for the effect of dismissals on later outcomes in a case.
Sonia, can you just introduce yourself too, and for people who are interested in the issue of cumulative effects on sentencing in particular, and particularly in the federal system, just want to commend your work to the group, but please let folks know who you are and what you have just written. Okay.
I'm Sonia Starr. I teach at the University of Michigan. I'm visiting here at Harvard this year. Yeah, I've been studying racial disparities in the federal system, and particularly looking at charging disparities and how they influence ultimate sentencing, sentencing outcomes. So this real interplay of stages I'm quite interested in, but in the federal data, they actually don't have data on pretrial detention status, and this mechanism for pretrial detention influencing outcomes is sort of, at least in theory, would need to be an important one. So one way I think that you could talk about like what is the impact on outcomes is to say, if you didn't, in the sentencing regressions, control for detention status, how much bigger would the disparity that you measure be? And the difference between those things in sort of a statistical decomposition model is actually pretty simple. You just like subtract the estimate when you do control for something from the one when you don't. You say that's the percentage, the number of percentage points of racial disparity in sentences that can be attributed to bail decisions. So that could give a sense of like what are the consequences of the disparity in bail and motivate future bail reforms and similar to other precedents.
Yeah, that's an excellent idea. Thank you.
Mr. Stewart.
90% of the cases that my office prosecutes are initiated by agents or by police officers. It's rare that we actually tell them exactly who to go after. So it seems to me that a huge driver in racial disparities is who the law enforcement frontline folks are targeting. And a question for Whitney, has Vera done a similar study for a police department or law enforcement agency? And if not, I'm just curious about the strategic thinking as to why not, and why starting with prosecutors. And then with Nitin, I'm just curious how the police responded to the changes that your office initiated.
Vera completed a very important work on stop and frisk recently that I would recommend folks look at. And so that, I think, is probably the most significant recent work on policing and racial disparity. So please take a look at that. Vera has a long history of looking at policing, but not in the context of racial disparity explicitly. And PRJ is the one and only Vera program to date that focuses on racial disparity as its reason for being. So,
sure. Carter, you may have missed my initial comments, but when I was talking earlier, I was talking about developing relationships with the courts and other stakeholders, the defense bar, and surprisingly, we have developed an excellent relationship with the NYPD. So all of these different initiatives and pilots that we are starting or about to start is with their cooperation, and they're a partner at the table with us.
Nate.
I think it's unfortunate to say this, but I would guess that most people in the room aren't shocked by the disparities between black and Latino defendants and white defendants. But I'm really surprised by the relatively lenient treatment for Asian defendants relative to white defendants. Could you talk a little bit about kind of why that may be, or speculate in that regard at all?
I mean, it's noteworthy that those differences are that at just about every point the outcomes were better if you're for Asian defendants than white defendants. I mean, and that is when you control for a range of things that you think might explain that difference. So the other characteristics such as gender, type of charge, number of charges, severity of charge, and so in a sense, that was a small portion of the sample that we had. I mean, I think the number of Asian defendants in that case were maybe 2%.
Right, it was a very small sample size relative to the 222,000.
Yeah, exactly. Small but significant. I think because of the small number and the perhaps lack of concern and more punitive outcomes, it wasn't something that we focused a bright lens on in terms of the analysis. But I think it would be and again, raising more questions, but I think it would be a fascinating topic and an important topic to look at what is happening there and what some of the reasons are. So yeah, I mean, but unfortunately we haven't conducted much analysis to look into that in detail.
I think we have time for one more question before we break and then switch to the next panel. Chris?
I was just wondering, in terms of, you mentioned comparing similarly situated defendants, and one way, for the women's question in front, you were saying, well, you're only comparing people who are in pre-trial, who are held pre-trial for the plea offer thing because of the effects that go on. One of the other really important things is the arrest record. And it occurs to me that two prosecutors or two judges could look at two different rap sheets of persons A and B, and they could think one is worse than the other. They could disagree on who's worse. So how specifically, because I know this was a task that you had to do manually. There was no data string that you could pull to analyze rap sheets. So how exactly did you sort of measure up the criminal history of the people you compared?
We did have information on prior records for the cases as part of the administrative data that was provided. There's a statistical technique which is known as binary logistic regression, and basically that is a way of statistically controlling for the fact that these things are related to one another. So the fact that somebody who's older is likely to have more prior convictions, so you can look at whether the different outcome is because that person's older, or is it just the fact that people who are older tend to have these longer records. And so one of the independent variables, one of the things that we put into those models was a number of things related to prior records, and it was number of prior arrests, number of prior convictions, and also some things about the type of offence that people have been arrested for previously, and particularly whether they have prior violent felony offence records, because all these things, of course, are important. And again, as I mentioned, that could be a source of disparity in itself, because people of colour tend to accrue more prior records for a range of reasons beyond anything to do with their individual behaviour. So in a sense that we are comparing people, we are controlling for those things, but then also perhaps we're in terms of that analysis missing some of the sources of bias that may lead to different outcomes. I'm not convinced I answered your question.
So what I heard was that you counted convictions, you counted arrests, and for certain types of convictions or arrests, like you mentioned, violent felony offenses, you maybe multiply them by a coefficient to give them more weight?
No. We just we controlled for their effect. We didn't make, when we put things into the statistical model, we didn't make judgments about which was a more important predictor, although the results did indicate, which things tend to be more predictive of the outcome. And so what we did was we said, of all these things that may predict the outcome, let's see how important each one is. And that's why I mentioned that there are many other things which predict sentencing outcomes, for example, more powerfully than race. And so things like, legal representation and number of prior convictions and those kind of things. In terms of the details about how you go about doing that, how the model works, I would refer to one of my statistician colleagues to tell you that. But the principle is that we don't make a priori decisions about what is more important. The model, when the analysis provides information about the relative importance of different factors, though, when you take other things into account.
Okay, here's what we're going to do. We're going to take a few-minute break to switch panels. The next panel, as I mentioned before, is Cyrus Vance and John Chisholm. We will continue in that panel with some of the discussion about this and talk about some other challenges that they both face as district attorneys. I really strongly encourage you to stay for that panel. Before we break, I want to thank Nitin, Whitney, and Jim for their presentation, for their work, and also their organizations for the work that they've done on this issue. Thank you.